Hello friends, welcome back to Steno World. Now I am going to dictate Supreme Court's original judgment at the rate of 100 WPM. So get ready for the dictation. 3, 2, 1, start. As the order passed in terms of the minutes of order is an order in invitum when a document styled as minutes of order signed by the advocates for the parties is tendered on record, the court must first examine whether it will be lawful to pass an order in terms of the minutes of order. The court must consider whether all necessary parties have been implicated to the proceedings in which the minutes of order have been filed. The court must consider whether third parties will be affected by the order sought in terms of the minutes of order. If the court is of the view that necessary parties were not implicated, the court ought to allow the petitioner to implead them. On the failure of the petitioner to implead them, the court must decline to pass an order of disposing of the petition in terms of the minutes of order. The reason is that an order of the court passed without hearing the necessary parties would be illegal. The court must remember that though the parties may say that they have agreed to what is recorded in the minutes of order, the order passed by the court based on the minutes of order is not a consent order. It is an order in invitum only if the court is satisfied that an order in terms of the minutes of order would be legal. The court can pass an order in terms of the minutes of order. While passing an order in terms of the minutes of order, the court must record brief reasons indicating the application of mind. For the convenience of the court and as a matter of courtesy, the advocates draft minutes of order containing what could be incorporated by the court in its order. Perhaps this practice was evolved to save the time of the court. The advocates who sign and tender the minutes of order have greater responsibility. Before they sign the minutes of the order, the advocates have an important duty to perform as officers of the court to consider whether the order they were proposing will be lawful. They cannot mechanically sign the same. After all, they are the officers of the court first and the mouthpieces of their respective clients after that. Even if parties file consent terms, while accepting the consent terms in terms of Rule of Order 23 of the Code of Civil Procedure Code 1908, the court is duty bound to look into the legality of the compromise. The court has the jurisdiction to decline to pass a consent order if the same is tainted with illegality. However, an order passed by the court in terms of compromise recorded in the consent terms is a consent order which will not bind the persons who were not parties to the consent terms unless they were claiming through any of the parties of the consent terms. We summarize our conclusions regarding the concept of the minutes of order as follows. The practice of filing minutes of order prevails in the Bombay High Court. As a courtesy to the court, the advocates appearing for the parties to the proceedings tender minutes of order containing what could be recorded by the court in its order. The object is to assist the court. An order passed in terms of the minutes of order tendered on record by the advocates representing the parties to the proceedings is not a consent order. It is an order in invitum for all purposes.